Good afternoon. My name is Mark Watkins, and I am a Georgia attorney licensed here in Georgia, specializing in criminal law. The purpose of this video is to discuss the Kenneth Walker arrest and Breonna Taylor murder in Louisville, Kentucky on March 13th, 2020. First and foremost, as I said, I am an attorney here in Georgia. I am not licensed in Kentucky. I have not practiced law in Kentucky. However, I have well over 15 years experience in criminal law here in Georgia. So I'm very familiar with criminal law, criminal process, although not unique to Kentucky. So the things that I'm going to be discussing are in the realms of the overall area of criminal law. So not necessarily specific to Georgia, to Kentucky, unless and until I mention Kentucky law specifically. With that being said, on or about March 13th, 2020, law enforcement officers of the Louisville, Kentucky Police Department or some law enforcement agency in Louisville executed a search warrant on the residence of Miss Breonna Taylor in the early morning hours around between 12:15 and 12:30 that morning. In her residence was Miss Taylor and Mr. Walker, who were both in the bed asleep, according to Mr. Walker's statements. What occurred was they heard a loud noise, were awakened from their sleep. When they heard the loud noise, they called out, either one or both of them called out to see who was there. Hearing no response, Mr. Walker picked up a firearm, and when somebody opened the bedroom door, he fired. In return, there was a hail of bullets, approximately 20 or more, which missed Mr. Walker completely, but killed Miss Taylor, who was in the bed. Miss Taylor was pronounced dead not long after, and Mr. Walker was taken into custody for attempted murder. Attempted murder of a law enforcement officer specifically. What occurred was law enforcement was investigating a particular individual who was known to go to Miss Taylor's residence, and it was believed that this individual was a drug dealer. The individual was allegedly having his mail delivered to Miss Taylor's residence, so the officers got a search warrant not only for Miss Taylor's residence, but for another place where he was known to frequent. I believe they used the term trap house where illegal substances are bought and sold. It's not alleged that Miss Taylor herself was a drug dealer. Mr. Walker was not listed on any of the warrants. It's just a search warrant in order to search the premises in order to find perhaps contraband, illegal contraband. The warrant was what's known as a no-knock warrant. What a no-knock warrant is a warrant that gives law enforcement the authority to enter into the residence without knocking on the door and saying, hey, police department, open up. The purpose of a no-knock warrant is for the element of surprise. The officers want to be able to enter into a domicile, secure it, and seize whatever items they feel are illegal without the potential of a bad guy or a bad person arming up and shooting back at them or to dispose of or destroy evidence. So that's the purpose of a no-knock warrant. They execute these warrants in the middle of the night so that it increases the element of surprise. If you're in your bed asleep not knowing what's going on, the likelihood of you being able to dispose of or destroy evidence is limited, which is in the minds of the law enforcement officers. Okay? So that's what we have happen. Mr. Walker is a legally licensed gun owner. That means he's gone through all the process that Kentucky requires in order to get a carry permit for his weapon. Now, normally, if you're legally entitled to own a gun, you don't need one, you don't need a license just to have one in your own home or in your vehicle. I know that's the way it is in certain jurisdictions. I can't say specifically about Kentucky, but we do know that he had gone through that process. He has shown the state and us that he is not a criminal because he has a license issued from the state that says that he can own a firearm. Okay? So what we have is Mr. Walker in the bed in a place where he is entitled to be, not violating the law. He hears a loud noise and he arms himself. When somebody opens the door who he doesn't believe is supposed to be there, he does what we all would probably do in a situation like that, and that's fire. If you're not hearing someone announcing themselves, if they're not giving you instructions, if they're not saying, hey, we're law enforcement, then I think it is a normal, natural response to think that your life is in jeopardy, arm yourself, and pull the trigger. It must also be noted at this time that it's alleged that the officers, when they executed this search warrant were in plain clothes. That means that they weren't in any type of uniform that identified them as law enforcement officers. So if you're awakened in the middle of the night, groggy, hear a loud noise, and you're scared, and somebody comes in your door, they're not in uniform that identifies them as law enforcement, what are you supposed to think that they are? There to arrest you or there to harm you? In interviews that were conducted by law enforcement of neighbors, the neighbors are saying that no one heard the officers announce themselves as police officers. Mr. Walker himself in the interview indicated that he had not heard the officers identify themselves as law enforcement officers. So all of us are thinking, when we see the situation, that Mr. Walker was doing what a normal person would do, and that is defend themselves. In the state of Kentucky, they have a self-defense law, which can be found at 503.055. Basically, Kentucky's self-defense law says that you are legally authorized to use deadly force if you feel that your life or the life of a third party is in danger of being harmed. Under 503.055, it's believed that Mr. Walker was well within his rights to do what he did, and that's fire upon an unknown intruder. Further in that law of 503.055 is section 2D. That's 2 delta. And basically, you're not authorized to use deadly force against a law enforcement officer who is in the legal commission of their duties. Okay? So what that means is, let's say that you are about to be arrested. They have a valid warrant for your arrest. You're not authorized under Kentucky's self-defense statute to then pull out your gun and shoot a law enforcement officer and claiming self-defense under 503.552D. You're not able to do that. And the situation that's unique to Mr. Walker's case is that they weren't identified as law enforcement officers. It's my belief that when Mr. Walker fired the shot, he did so not with any type of criminal intent, but in order to protect himself. Now, at some point, Mr. Walker was arrested. He was charged with attempted murder of a law enforcement officer. He was subsequently released on his own recognizance, which means an OR bond, or he didn't have to put up any money, and released to home arrest, where he will be monitored by an ankle monitor. This, of course, put law enforcement in that jurisdiction up in arms. It made them angry because they feel that Mr. Walker tried to do harm and actually did do harm to one of their officers, so he should not be afforded the opportunity to be at home, even though there's a potential that he did not violate the law. Now, again, that's not up for me to decide, but it's up for a jury and judge to determine whether or not Mr. Walker did, in fact, violate the law. Again, I'm not an expert on Kentucky law, but in my review of Kentucky's self-defense statute and applicable case law, I came across a case entitled Commonwealth v. Albert, which is a 2018 case. Albright, I'm sorry, I said Albert. It's Commonwealth v. Albright. It's a 2018 case and can be found at 2016-CA-001352-MA. That's 2016-Charlie Alpha-001352. It's a 2018 case. In the Albright case, what occurred was there was an individual who heard gunshots. He was inside of a store. He heard gunshots. He armed himself, went outside, and saw two people struggling on the ground. There was a gun that was in the possession of one or both of the individuals. Basically, they were fighting over the gun. During the commission of this fight, the gun went off in Mr. Albright's direction. He was not a party to the fight. He was basically a bystander. Mr. Albright then took the gun that he had legal possession of and shot both of the individuals, killing one. Mr. Albright was then immediately arrested and charged with murder along with a host of other crimes. Mr. Albright's defense attorney then filed a motion to have the case dismissed, citing Kentucky's self-defense statute. The trial court agreed that he was legally authorized to shoot because he feared that his life or the life of others was in danger, and dismissed the indictment. The Commonwealth, or the state, then appealed the trial court's decision to the Court of Appeals. Appeals basically said, well, you know what? Mr. Albright was in a location that he was entitled to be. He was legally armed, and he felt that his life was in danger, and therefore the indictment should, in fact, be dismissed. It is my humble opinion that based on the Albright standard, based on the standard of self-defense, and based on the standard of common sense, that Mr. Walker should not be charged with murder. And if he is charged with murder, it is my opinion that his indictment should very well be dismissed based on the Albright standard. In Albright, the court used a standard of totality of the circumstances standard to determine whether or not there was probable cause for self-defense claim. Okay, they looked at all the events surrounding the incident involving Mr. Albright to see whether or not he had a legal justification. And again, the standard was a totality of the circumstances. Again, it is my opinion that based on the totality of the circumstances in Mr. Walker's case, the fact that he was a legal gun owner, the fact that he was not the subject of an arrest or search warrant, the fact that he was awakened in the middle of the night, the fact that the officers entered the home not in uniform but in plain clothes, the fact that there's testimony that they didn't identify themselves as law enforcement, and the fact that he was awakened in the middle of the night, based on the totality of these circumstances, it seems to me that this is a clear case of self-defense. I don't know what's going to happen to the case. It is my belief that once he is indicted, the defense attorney should very well file a motion to dismiss based on Albright to have this case thrown out of court. I don't think anybody under similar circumstances would have acted in a different manner than Mr. Albright did. He had a right to defend himself, and that's what he did. I don't believe he had criminal intent, and therefore I think that the charges against him should be dismissed. Feel free to leave any comments. I don't have anything whatsoever to plug other than just getting out there the information that I found, the review that I've done in these particular facts. I know that there are people who don't agree, but unless you are a licensed attorney, specifically in Kentucky, your disagreement will be just on your feelings. Now, even the most ardent 2A Second Amendment supporter should find no fault in my rationale, no fault in my argument that what Mr. Walker did on that particular day was self-defense. Unfortunately, in looking at the facts, I don't think that anyone will be held criminally responsible for Miss Taylor's death, and that is unfortunate. I believe that there is a civil attorney now representing her family who will probably file suit against the city of Louisville, maybe the state. Whatever they get, of course, will not bring Miss Taylor back, and it is unfortunate, but I think that is the only symbol of justice that they may receive, which is a financial settlement, not a criminal prosecution. So once again, thank you very much for your time.